In this bulletin, an expert in US international law and international trade claims Canon has run out of realistic options. Hello, I'm David Gibbons here in Zhuhai, China, and I have Merritt Blakeslee with me from the United States, from the East Coast. Hi there, Merritt. Are you in Washington, D.C., or are you further up the coast?
I'm further up the coast, David. How are you this morning or this evening, your time?
Yeah, well, whatever time of the day it is. I think we're 12 hours apart. Merritt, you've been practicing practicing the fields of international law and international trade regulations in the United States since 1991. So you've got a fair bit of a background there and interest in this and the imaging supplies industry, I guess, from this perspective.
That's true, David.
Well, Canon is one of the hot topics at the moment because they have lost the case and lost the appeal in the Federal Circuit in their case against the International Trade Commission. And I'm not sure what's going to go on from there, but certainly it's a big win for the aftermarket. Canon has had many wins in the past against those who infringe against its intellectual property rights, Merritt. Why do you think, in this case, the aftermarket has gained such a significant win?
I think of this entire Canon episode as a parable of the way that the framers of the U.S. Constitution intended the U.S. patent system to work, which was to encourage innovation. And Canon has been more aggressive, I think, it's fair to say, than any OEM in our industry in using its enormous patent portfolio to protect market share. Canon has more than 3,500 US patents. That's only its US patent portfolio. And so beginning in 2014, it began what we can call the dongle gear campaign to recapture its market share in its toner cartridges from the big aftermarket players, which were making larger and larger inroads. And I don't accept the proposition that Canon has been largely successful. I think that Canon has suffered not one, but two back-to-back losses in precisely in this campaign of asserting its patents against the aftermarket. As you know, in 2014, it filed the 918 investigation against the big market players, asserting its dongle gear patents for the first time, and it got a general exclusion order in 2015. That's supposed to be the gold ring. That's what everybody goes for. That, in fact, was a resounding loss for Canon because before the ink was dry on the GEO, every major aftermarket player had come line around. And
just a minute, Merritt, we've got a very bad line here at the moment. Could I just pause you there for a second? Could you just go back a few seconds and talk about why it was such a... Could you just go back a few seconds and say, why was it such... take it from the point where the ink wasn't even dry on the paper, and then sure. We lost you. Maybe you could pick it up from there.
All right. The ink was barely dry on the general exclusion order before the products that the exclusion order was intended to keep out of the United States stopped being manufactured and shipped to the United States and were replaced by a new generation of designer rounds that simply evaded the restrictions of that set of patents. So Canon had spent an enormous amount of money and come up really with absolutely nothing. So it went back to the drawing board, filed a new family of patents, which were directed precisely at the features of the new design arounds, and brought those in the 1106 investigation in 2018. And there, Canon suffered a second resounding loss. The ITC and now the Federal Circuit have ruled that its attempt to go back and rewrite its patents shouldn't be permitted. So I think that this brings us to something of an existential dilemma for Canon. As to its options, I think that it is at the end of the road, end of the legal road with respect to this family of patents. It is true, well, it's worth remembering how the Federal Circuit, the Court of Appeals for the Federal Circuit, delivered its decision. Remember, the Federal Circuit is where all patent appeals go. And in mid-April, it held a three-judge panel, entertained oral arguments on the Canon appeal. In a mere 10 days later, they issued their decision, and it was the sharpest, most brutal way to inform an appellate that they had lost. They issued a one-word decision that said affirm. It's called a Rule 36 decision.
And it was unanimous. It was unanimous as well.
It was unanimous, absolutely. Canon now legally has three options to reverse that decision.
Okay, there are some options now that Canon could go with.
There are options, but they are very, very poor options. It could ask the three-judge panel for a rehearing. It could ask the entire Federal Circuit, which is about 20 judges, to hear its case, or it could appeal to the U.S. Supreme Court. The chances of succeeding on any of those is very, very small. I do think that Canon has another option, though, and that is that it could rummage around in this extraordinarily large portfolio of patents and see if it can't isolate another feature of its existing toner cartridges and that is covered by one of these patents that it had not asserted previously, and assert that in a new round of litigation. If it does so, I think that we will begin the same game of cops and robbers, where the aftermarket then produces a design around or a series of design arounds that get around the newly asserted patents. In other words, I think that Canon is in a very, very difficult position in using this strategy, which for so long was successful, of protecting its market share with its intellectual property portfolio. Yes. I think that because of the ability of the aftermarket to design creatively around intellectual property, I think that Canon has a tough road ahead of it.
Originally, there was some 40-odd defendants that were, listed, and many of those, folded over and, said, all right, we won't sell these products anymore. But there was just a small group of them, Nine Star, Printright, to Astor, and LD Products, and some of these companies that decided to fight it. Do you think that Canon underestimated the aftermarket's ability to stand up and fight, and really was always hoping that everyone would have just fallen over because they couldn't afford a legal case or just couldn't afford to take this battle further, and they've been caught surprised by all of this?
Well, 2 points, David. First, those who rolled over early, including some of my clients, simply agreed to stop selling the old product and immediately turned and began selling the design around. They didn't leave the market. They simply changed to a non-infringing design around.
Okay.
I do see that the 1106, in my view, the 1106 investigation by Canon's decision to file the new patents and then try to litigate on them was an act of complete desperation. Their legal arguments were paper thin, and ultimately they didn't prevail. So I really see that this, as I say, this is the culmination of a series of defeats for Canon.
Well, it's going to be interesting to see what happens next, because as you said, if they come out with a different patent or a different product, and then say, hey, these aftermarket are infringing, before, as you use your words, before the ink is dry on the paper, there will be a workaround solution that will come out, and there's this, leapfrogging backwards and forwards all over again. And it seems that Canon really cannot win, and that there is a place for a legitimate aftermarket after all.
The aftermarket has become, over the period of this litigation, has become very, very agile and very creative, very innovative in developing products that are legal. That's a change from the old days of a decade and a half ago, when the aftermarket was not particularly sensitive to intellectual property concerns. Now they are hypersensitive and very, very good at operating within the bounds of the intellectual property laws.
Merritt, thank you very much for joining me today.
Thank you, David. Stay well.
And you too. Keep well.
Right. Goodbye.